Assalamu alaikum. Welcome back to Just Law Nikra TV. I'm your host Bilal Hussain Khan from BKP Solicitors. Now, this is a live call show, and our callers are urged to give us a call. There will be a number at the bottom of your screen, and you will be put through to me, and you can ask any questions regarding any immigration law issues you have, any criminal law issues you may have, or any other aspect of English law. Now, just before the break, we was talking about the procedure for drink driving, and at the second segment, I will talk through the drug driving procedure. If you are suspected of driving a motor vehicle over the prescribed limit of drugs, then what the procedure is and what the inevitable outcome will be. Now, insofar as drug driving is concerned, it's for the officers to suspect initially that you've taken over the limit of the prescribed amount. Now, usually what we find before the courts is cases where officers have stopped an individual for another reason, and whilst doing so, whilst approaching the vehicle, they've smelt cannabis, and therefore they're alerted to the fact that the driver may have smoked cannabis, therefore may be driving a motor vehicle with over the prescribed limit of THC in their system. Now, what they'll do is they'll request a roadside sample, and that'll consist of a road swab, a mouth swab, and then what they'll do is they'll swab your mouth, and then if there is any drugs detected on it, then you'll be arrested, cautioned, taken to the police station. Now, once at the police station, once a custody sergeant has authorised your detention, you will be invited into the intoxilizer room, and then what will happen is a nurse will be brought in, because like I explained previously, insofar as drink driving is concerned, the officers will conduct the procedure with you. They'll ask you to give 3 samples of breath, and the machine will then detect how much alcohol is in your breath. Now, the legal limit is 35. Anything above 35 micrograms in 100 milliliters of breath will be above the prescribed limit. Therefore, you will be charged with the offence. Now, insofar as drugs are concerned, when you're taken to the custody suite and taken into the intoxilizer room, a nurse will be brought in to take a blood sample from you. Now, that's the only way that they can get the sample from you. Therefore, they'll invite you to provide the sample of blood. Now, what will happen is 2 samples will actually be taken, 2 small bottles. They'll be opened, they'll be sealed. The seal will be broken in your presence, and then the blood sample will be taken, put into both of the containers. One will be sealed and will be placed into secure facilities by the officers that will be kept refrigerated. The second one will be given to the person who the blood is taken from, and they'll be advised to keep it refrigerated, and if they would like, then they can get their own analysis of the blood. Now, obviously, blood analysis cannot be conducted by police officers, so what will happen is the officers, once they've taken the blood, usually nobody is interviewed, so you'll not be interviewed for this offence, because at that stage it's not known what the reading will be. Even for drink driving, where officers know what the reading is because the machine has provided the reading, 9 out of 10 times, unless there's any other offences attached with it, then you will not be interviewed. You'll simply be charged with the offence. And for drug driving, you'll be released under investigation for the offence. You'll be reported for a summons, and the officers will say that, look, if the amount of drugs inside your blood is above the limit, then at that stage what will happen is you'll be prosecuted for the offence. Now, the amount of drugs inside your system, insofar as cannabis is concerned, the element of cannabis that is banned is THC, and the scientists will specifically be looking for THC in your blood. Now, if there is more than 2 inside your blood, then at that stage you will be charged with the offence. Now the scientists will say that this was 2.1, 2.2, it was 3, 4, 10, whatever it may be. The higher the concentration, the more serious the offence is. Now, usually we find that people are charged for the offence after about 3 or 4 months, because the blood is sent to a lab. That lab then analyzes the blood and then provides a statement to the police. The police will then send that document over to the Crown Prosecution Service or the police prosecution team, and then a pack will be created for court purposes, and then you'll be charged. So by that time, there's been a significant delay from the time that the blood has been taken to the time that you've been charged. Although the police expert will have examined your blood within the first couple of weeks. Now that begs the question, what happens with the blood that you've been provided? Now when you've been provided that blood, you've been given the instructions, it's been sealed, you've been told keep this refrigerated. It may be the case that you want to get your own expert to analyze the blood. Now what's important to note is the concentration of the various elements in your blood will deteriorate over time. So if bloods were taken today, the concentration of the drug will be accurate because the blood has just been taken today, the scientist has tested it today, and this is what the sample was. Now if the police have had a look at it a week or 2 later and they found that there's above 2, the report will be made, you'll probably be charged. Now you're not going to know that you're getting charged until you receive the paperwork, which sometimes is 4 or 5 months later. Now what a lot of people do is they keep the bloods inside the fridge, thinking if we're above the limit, or if the police allege that we're above the limit, then at that stage we'll get our own analysis done. Now unfortunately what will happen is if you have your bloods analysed after 6-7 months and then your blood comes below the limit, then there'll always be the argument that wait a minute, you've not done it within the time frame. It may be the case that the blood was not stored correctly, etc. So it's always important to know that if you are wanting to defend the case on the basis of the analysis, then it's quite important that as soon as you're released from custody, then at that stage you source an expert to have a look at your blood and provide the report accordingly. There's been cases where people have done this after they've been notified that they're going to be charged. The reading has been 0.2 or 3. Now in one particular case that I dealt with, the prosecution's analysis was 2.2. Now the defendant never knew that he was going to be charged with this until 6 or 7 months later, and then he had his analysed and it was below the limit, it was 1.7. But the problem is the prosecution argued and our expert agreed that because of the time frame between the prosecution's analysis and the defence analysis, there's been a significant delay of about 7-8 months, and that reading could be deteriorated or it won't be accurate, because the closer it was to the episode of driving, the more accurate it's going to be. So there's always that to know. So if you ever find yourself in a position, then it's important that you should get the blood analysed as soon as possible in order to get a more accurate finding. Then at that stage you'll know whether you was above the limit or not. Unfortunately, there is no legal aid available for you to have your blood analysed pre-charge. Post-charge is a different matter, it depends on a case-by-case basis, but pre-charge you will have to pay for that yourself on a private basis, and whatever the labs charge is a matter between the person, the suspect, and the lab that's doing the analysis. Now, what is the procedure then? If you go to court, then you'll be requested to enter a plea. Now, the prosecution will believe in certain cases that you are either going to plead guilty or you're going to plead not guilty. Now, in anticipated guilty plea cases, the prosecution will not serve all the evidence. Now, it's for the prosecution to prove a case, and the prosecution is duty-bound to serve the forensic reports. There's something called a SFR1 and a SFR2. Now, if the prosecution do not serve these documents upon the defense, upon the court, they cannot prove the case against the person. Therefore, it's always important, if you find yourself in a position, you always consult with a solicitor who specializes with these matters, and then see whether or not the police can prove the case against you. Because majority of the times, the cases that I've seen come before the courts, there's only a case summary, there's no forensic analysis, there's no evidence whatsoever, and the police expect people to just plead guilty to the offence. And majority of the times, the prosecution fail to serve the forensic reports, etc., which means that the defendant is found not guilty of the offences. Now, quickly dealing with the sentencing guidelines. Now, for drink driving, depending on what your reading was, 35 is the legal limit. If you blew between 35 and 45, and then between 45 and 50, etc., depending on what your reading was, the sentence will be in accordance with that. So the minimum disqualification you're looking at is a 12 months disqualification, which will be reduced if you're offered a drink driver's rehabilitation course. Now, at the time of being sentenced, you need to opt for that and say to the magistrates, I would like to do that course. And if you successfully complete that course, your disqualification will be reduced by a certain amount. Usually it's about a quarter. So, now, if you have another drink driving offence within the last 10 years, then your sentence will be a disqualification of a minimum of 3 years. That's quite important to note. So for the first time round, for a small reading above the limit, it'll be 12 months. Second time in 10 years, you're talking 3 years. Now, if we look at drug driving cases, now whatever the drug may be, if you're above the legal limit, then ordinarily the minimum disqualification that you will receive is one of 12 months. Now, unfortunately, there is no drug drivers rehabilitation course or anything like that. So whatever the disqualification you are given, it is that. And it all depends on what your reading is. Now, there's sentencing guidelines for these offences. Now, it depends if any of the drugs were found in your system, which will be an aggravating feature. It'll depend if the standard of your driving was quite bad, whether there was an accident, whether there was any injury caused, etc. All of these considerations will be taken in, and then you'll be given your sentence. Now, the higher your reading was, the higher you were from the legal limit, the longer period of disqualification you will receive. Now, at the end of any disqualification, be it a driving, drink driving, drug driving, etc., you do not have to retake your test, but you have to apply for your license again. You're not going to automatically be given your license. Now, it's quite important for you to know that, because quite a lot of people are under the false pretense that they've received a 12 months disqualification, which means after 12 months I can jump in my car and start driving. No, unfortunately, you're not going to. You have to reapply to the DVLA, and the DVLA then will issue a new license, a new card, which will be issued for a period of 10 years. Now, if you drive without requesting a new license from the DVLA, then at that stage you'll be driving without a license, which means that will invalidate your insurance. Therefore, you'll be driving without a license, and without insurance. Now, for that, you'll be receiving penalty points of approximately 8 points. Therefore, it's quite important to know that you need to reapply for your driving license at the end of any disqualification. Now, there is certain cases such as driving whilst disqualified, dangerous driving, where you don't automatically get your license back and you'll have to take an extended test, etc. But we'll deal with those aspects in the following weeks. Now, I hope the show today has been quite useful, and if there is any suggestions of the following weeks, what to talk about, we'll do. Until then, I hope everyone stays safe, and Assalamu alaikum. I'll see you next week.